at the time. Let's quickly get our final panelist to take the podium. Professor Kwamena Ahwoi is a legal and governance expert. Let's welcome with a round of applause.
Thank you very much. When I got the concept paper from the organizers and I looked at the title, I thought that they had the wrong title. Because the issue really is not the role of the civil service in the execution of the president's mandate. The issue is the role of the presidential staffers. The civil service is there. It is a constitutional body to execute the president's mandate. If the president is bringing people from outside to do what the civil servants are supposed to do, then that is where the problem is. It is not with the constitutional body that has been established. So I will change the topic to executing the president's mandate, the role of the presidential staffers. My three previous speakers have all spoken without reference to where the real problem is. You see, the civil service is regulated by the Civil Service Act of 1993, PNDC Law 327. The local government service is regulated by the Local Governance Act of 2016, Act 936. But there is a Presidential Office Act, which is regulated, there's a presidential office, which is regulated by the Presidential Office Act of 1993, Act 463. And that is where the problem is. All the suggestions that have been made, they are true, but they are actually covered under the Presidential Office Act. Except that it is an act that is so bad, but presidents have found it so useful that nobody has talked about revising or amending the act. The function of the presidential office is to provide the president and the vice president such services as they may require for the efficient and effective performance of the executive functions of the president and vice president under the Constitution and any other law. That is all their function. Now, if you don't take you will interpret this so broadly as to cover everything that the civil service and the public services do, because all of them are assisting the president and the vice to perform the executive functions of state, their executive functions. So the function assigned to the presidential staffers is so vague as to amount to duplication and overlap. The idea, because I was part of the team that drafted that act, it's one of the first acts that we passed, the first government of the Fourth Republic. The idea at the time was that when advice has been tendered or options proposed by a civil servant or a member of the local government service, the presidential staffers will check for their consistency with the president's vision, his program, and the party's manifesto. It was never the intention that the presidential staffers will substitute the bureaucracy and then the technocracy. It was never intended that they will compete and rival the civil servants and the members of the local government service in their roles for which they have the requisite qualifications, training, knowledge, expertise, and experience. Now, if you look at the features of the presidential office and all the people they've been describing, they've all been appointed under this act. Because outside of this act, the president has no other appointment powers apart from those contained in the Constitution and in the other laws. The president is the one who assigns duties to the presidential staff. This is in Section 3. The number of presidential staff and their ranks and grades are determined by the president. They hold office at the pleasure of the president, otherwise they have the same tenure as the president. Their salaries, allowances, and facilities are determined under Article 71 of the Constitution, and so on and so forth. There are many problems with this act. First, there is no limit to the number of presidential staff that a president may appoint. And that is why this problem has arisen about numbers. No matter the number that you appoint, a president is acting within his powers. The only limitation is that he must announce or report the number that he has appointed to Parliament. But there's no upper limit to the number that he can appoint. There is no designation of the offices to which the presidential staff may be appointed. There is no indication of the ranks and grades to which the presidential staff may be appointed. There are no qualifications for the persons who may be appointed presidential staff. The lack of security of tenure of this staff constitutes them into a special category of political public officers who are outside the civil service and the local government service. They are therefore not subject to the disciplinary and other regulatory codes that other public officers are subject to. And the absence of the definition of the executive functions for which the presidential staff are to provide services, as I said, creates serious overlaps and duplications between their functions and those of the civil and local government services. Now, these problems create the following, or have the following consequences. First of all, it can lead to what is called a polycracy, which is an over-bloated government. When a government is made up of too many people, you get what is called a polycracy. It can also lead to profligacy, which is an excessively expensive government, because an over-bloated government is necessarily an expensive government. It lays the foundation for nepotism, which is a government of relatives. It is also a recipe for cronyism, which is a government of friends. And it is a recipe for patronage, which is a government of the sponsors of the president's campaign. It even leads to what is called a kakistocracy, which is a government of the unqualified people, because there are no qualifications for them. So these are what have had the adverse morale. When I listened to the gentleman, I didn't get the impression that they were completely averse to the intrusion of presidential staffers. I got the impression that they were worried about the numbers, and because I've been there before, sometimes they are worried about the qualification and the capability of the people who are appointed to either work with them or to substitute for them. But there's an important merit for this act. It is this: it enables the president to carry into his government members and staff of his campaign team, many of whom have no qualifications whatsoever. When a president is a candidate, he has a very large team that he works with: security officers, drivers, cooks, hangers-on, choboi people, all of them. So they work with him sometimes for 4 years, sometimes for 8 years. When he gets elected, without this act, technically all of them get cut off because the state takes the president over. And from a human point of view, it is very, very difficult to terminate somebody who has helped you enter into office in that manner. So this is the law that enables a president to transit his campaign team into office as president. Now, so it is not bad. But from the little analysis that I have made, it points to only one direction. In fact, Prof made a point. When he said that we must have a cap, maybe we should allow some people to go with the president into office. All that is true. But what it means is that we must revise Act 463 along the following lines. We must put a limit on the number of presidential staff that a president may appoint. We should have a clearer and more precise definition of the mandate of the presidential staff to avoid the overlaps and the duplication with the mandates of the national bureaucracy and technocracy. Parliament must enact an ally to determine the offices, the ranks, and the grades of persons to be appointed presidential staff. There should be a more rigorous procedure for the appointment of presidential staff, because once you step into that office as presidential staff, many of them handle material that is more sensitive than what ministers and civil servants handle. But there is no system of vetting. of making sure that indeed these people are not security risks. Some of them may be, etc. We should decouple the method of payment of the emoluments of the presidential staff from those of Article 71 office holders. And then for flexibility, and especially to accommodate the campaign team members, maybe the president should be allowed to appoint a limited number of presidential staff, under the Act 463 arrangement. But for the rest, some qualification and some of the other things that I have said should be spelled out. And maybe in the president's annual report to Parliament, we should require him to justify why certain persons have been appointed to certain positions. Before I want to conclude by making reference to another law that has also created the problem that has worsened the problem that Mr. Kwamena talked about. And this is the Presidential Transition Act of 2012, Act 845. This was signed into law by late Professor Mills. The way it has been interpreted has had a devastating effect on the security of tenure of public officers generally. Instead of the objective of ensuring the security of tenure of public officers, the section has achieved the opposite effect of providing a framework for the insecurity of tenure of public officers. What Prof. Zade recommended actually is in that law. There is a section 14 in that act that says that lists the persons who come and go with presidents. Unfortunately, there's a section 14.1 which was drafted in a way that was not anticipated. The original draft, and again I know because I worked on it with Justice V.C.R. A.C. and Nana Tudati, was that a category of persons who would go with the president were persons appointed by the president or a minister as members of the board of directors of statutory boards and corporations. Unfortunately, when the law came out, this is how it read. Persons appointed by the president or a minister of state as members of statutory boards and corporations. The section has been interpreted by the 7th government of the 4th Republic to mean that every member of the board of directors, as well as all members of staff of statutory boards and corporations, cease to hold office on the assumption of office of a new president. Using this interpretation, the government has undertaken the following actions since January 2017. It has dissolved the governing councils and boards of all public tertiary institutions and regulatory bodies. I was chairman of the University of Ghana Council. The council had been in existence for only 6 months. The new government came, they dissolved it. Meanwhile, only 4 of the members of that council are government appointees. The rest are all institutional representatives. But not only legal, all public tertiary institutions, the boards were dissolved. It has been used to remove from office chief executives of the following and many other organizations. In fact, the list is so long. So he talked about 2. I have about 30. Ghana Cocoa Board, Volta River Authority, ECG, Food and Drugs Authority, Ghana Revenue Authority, Ghana Investments Promotion Center, Ghana Free Zones Board, National Communications Authority, Gaming Commission of Ghana, Head of the Local Government Service, Ghana Civil Aviation Authority, District Assembly's Common Fund Administrator, Ghana National Fire Service, National Petroleum Authority, GMPC, Ghana National Gas Company, National Health Insurance Authority, Ghana Tourism, very long list. If we don't do something about this provision, what it means is that effectively we have politicized every state institution in this country. Because if we live with that interpretation, it means once a new president comes, he can sack anybody at all. And I don't think that was the intention at all. Now, the constitutionality of that section and the government's action on it, I know, has been challenged in the Supreme Court. And the matter is therefore sub judice. So I don't want to go into the merits and demerits. But my own view is that the act should be amended by reverting to the original wording of the draft bill so that we know that it is persons appointed to boards of directors by the president and by ministers who are affected, and not everybody else who is working in the public service. Above analysis and recommendations are made to respond to the following critical requirements of democratic governance. It is to ensure separation of powers, checks and balances, avoidance of conflict of interest, transparency and accountability, the cost of governance, especially in a developing country, and the security of tenure of public officers. Thank you very much.
Thank you to Professor Ahwoi for that.